Mr. Chairman, we do have a quorum.
Onto the agenda. Has everyone had a chance to take a look and review the agenda for the day?
Make a motion to approve the agenda as presented.
I'll second.
Have a motion and a second. It's approved. I guess we do need to vote on it, though. Motion and a second. All in favor?
Aye.
Aye.
There we go. We're so used to doing roll calls
I know.
one at a time.
I was waiting on Mark to go there. Any nays? No. On to the minutes. Has everyone had a chance to review the minutes from the last meeting? I personally have not, because I didn't get them.
In your.
Okay.
Make a motion to approve the minutes as presented. If Scott's good with it, since he's the secretary.
I'll second.
Have a motion and a second. All in favor?
Aye.
Nays? Motion carries. On to the legal report.
All right, good morning. It's great to see you all in person and not on screen for the legal report. So I know you all are excited and we are as well. We'll start with the legal report with the first new case. Number 1 on the legal report, it's case number 20200981171. The summary is that the complainant entered into a contract with the respondent in June 2020 for an alarm system installation and for monitoring services. The term of this contract was for 36 months and for a monthly service charge of $63.99 per month. Several months later, the complainant decided she wanted to cancel her contract with the respondent and was notified that there would be an early termination fee that was calculated at approximately $1,500. The complainant also stated she was unaware of any early termination fees, as she stated she was told she would be able to cancel her contract at any time. The complainant also stated she did not have a copy of her contract. The respondent stated the complainant was under a legal contract and that the respondent would enforce the terms of the contract, including the early termination fee. The respondent stated the complainant was on a recorded call acknowledging the terms of the contract, including the early termination fee. The respondent did not provide the actual call, however, provided a written transcript from the call and copies of the contract and notice of cancellation policy, which were each signed by the complainant electronically. Based on these documents from the respondent, it appears the respondent did disclose all material terms, including the information on the cancellation policies, as these were covered in the signed documents in the transcript from the phone call. There is a concern that the complainant may not have been given a copy of the contract at its execution as required by Tennessee Compilation of Rules and Regulations 0090-06-.044. The respondent's documentation showed where the contract was signed and discussed, but there was no proof the actual contract was given to the complainant. The respondent may not have had included that or had proof of that being provided, but this was an allegation by the complainant that was not disproved by the respondent's provided documentation. Additionally, there is a concern that the respondent's license only holds a certification for burglar alarms and does not hold a monitoring certification. The contract between the parties showed the respondent was responsible for monitoring services related to the complainant's system. Counsel's recommendation is to close this matter with a letter of warning. The initial allegations by the complainant that the respondent did not disclose this cancellation policy are not substantiated, as the respondent provided signed documents showing the complainant acknowledged receiving this information and it was also acknowledged in the phone call to start services. The issue regarding the respondent's classification is substantiated, but it can be remedied through adding the appropriate classification to its license and based on the size of the company should have previously been addressed. The issue regarding the failure to provide the complainant with a copy of the contract should also be addressed in any warning, but may not have enough evidence to warrant formal discipline, as the complainant signed copies of the contracts electronically. The complainant also did not provide a statement to the board's investigator, so this issue regarding the contracts was caught by legal counsel for the board upon reviewing the documentation and statements collected by the respondent. Therefore, the recommendation is a letter of warning.
So a couple things I spot right off. The company, unless they own a monitoring station, they don't have to have a monitoring license.
Right. And I think that that's something that we were unclear about as to whether or not they were actually providing the monitoring or just holding themselves out as doing monitoring services. So I think that it could be a situation where the warning covers that to address whether or not they are holding themselves out as providing monitoring services while not actually providing them, or if they are actually providing the monitoring services themselves. At that point, it would be an issue with unlicensed activity.
Because all alarm companies provide monitoring, but my company, we contracted out.
Right.
So,
Traditionally, I mean, long before any of us were on the board, that's been the way in the past. There was not a requirement to have the monitoring classification if you weren't actually running the central station, if you were subcontracting.
Right. And I think the concern is mainly based on the language of the statute with the language in this specific contract. But if it is something where the board feels like that is not necessarily an issue based on the burglar classification, I think we could get around that issue.
Sounds like the bigger concern is that they're not getting a copy of the agreement. The rest of it's a civil matter, sounds like.
I agree, and I think that was part of the concern when we sent our investigator out to get a specific statement. We did ask for a copy of the contract, and the complainant did not provide any further information. So we were limited to what the initial complaint stated, and we didn't get our follow-up information. So they could have actually provided it, but because we didn't get that statement from the complainant, we don't know.
I'm okay with the letter of warning, but my issue is we don't know what was conveyed to the customer. So,
The complainant states that they didn't have a copy. You're saying, no, she didn't say she wasn't given one.
Correct.
So we just don't know that for sure.
Right. And I think that's the concern is if you're signing something electronically, typically that's also emailed to you. So we don't know if it was actually emailed to her and she just couldn't find it, or if there's a situation where she never actually received it. If she, clicked the button to sign and it went nowhere. So I think that's a situation where we could do a letter of warning and address that. We could also close it because the proof is not substantial.
I'm going to make a motion that we close it just because of the lack of proof that the company did anything wrong. I really don't see it. You assigned a contract, whether you did it in person or electronically. That's my recommendation.
I'll second.
Motion and a second. All in favor?
Aye.
Aye.
Opposed? Motion carries.
All right, thank you. So we'll move on to number 2, which is complaint number 2021009271. The summary is the complainant stated she purchased an alarm system and entered into a monitoring agreement with the respondent in 2016. She stated that the employee who contracted with her initially contacted her again in July 2020 and told her her contract with the respondent had expired and that he could get her under contract with a new alarm company. The complainant agreed, but when she later was billed for services by the respondent, the complainant made this complaint. The complainant also stated she would have never entered into the new agreement if she knew her contract with the respondent had not expired. The respondent agreed to work with the complainant to help her cancel her new contract. However, the respondent stated there would be a cancellation fee if the complainant canceled her contract early with them. Our investigator did not inquire as to the balance, as it appeared the issue was with this individual who had contacted the complainant or contracted with the complainant. Our investigator made contact with this individual and his registered employee registration expired in December 2017. He verified his information with our investigator and then sent him a picture of a screenshot from the state's Verify website showing the active license for an alarm company, which is a large company and he is not the owner of. When our investigator asked this individual about his expired registration, he said that he is no longer working in the alarm industry and denied working for that company at the time the complaint was made. We do not have proof this individual is still working in a manner that would require him to be registered with the board, but he is not properly or was not properly registered when he contacted the complainant in July 2020 regarding the installation of the new cameras and having her enter into a monitoring agreement with the new company. The recommendation is to close the complaint as to this respondent, but open a new complaint against that registered agent as an individual.
So initially, it was towards the company he had been working for?
Correct.
Do we have any legal standing or anything to go after because it's not really the registered employee's responsibility. I mean, I don't like what he did, and it's in violation of the rules, but I don't know that we have anything to go against him. It was the qualifying agent's responsibility to have him registered.
Well, I think we can go against that registered employee for the statements that he made, telling her that her system had expired. I think that's what we would be going after him for. And when I spoke to Director Vest about this case as well, she had recommended potentially opening a complaint against that second company that he was working for when he had told her to that her contract expired and to enter into that new contract.
But that's who I would think it would be. It would be the company he was working for later when he was trying to get her. Who was this complaint against? Is this against the first company or the second?
First company.
Oh,
right. So that's why, realistically, this complaint would have to close because there's nothing with that first company that was at issue. It's more of who is the registered agent we should go after or the new company. And I think part of the concern is the registered agent looks like he may be acting rogue and kind of doing these things on his own. I'm not really sure his actual relationship. It almost looked more like he was acting as some type of advisor, maybe to another registered employee who is a sales rep. It's very strange. So I think we could go against that new company as well as that registered agent for the statements he made. But if the board would rather go against just one of them, open that new complaint as one, that could occur as well.
I'd make a motion to close, but to ask that you further investigate the second company.
On the second.
I'll second that.
We have a motion and a second. All in favor?
Aye.
Aye.
Opposed? Motion carries.
All right, thank you. So next we have number 3, which is case number 2021023831. The summary is the complainant had a contract with the respondent for alarm monitoring, and after making attempts to cancel the contract, she was still billed for services not received. The complainant stated she had attempted to cancel the contract through certified mail as stated under the contract, but the letter didn't appear to ever be delivered. The respondent responded to this complaint and agreed to cancel the contract and waive any past due amounts. The complainant followed up by sending information to show issues she had with the mail tracking for certified mail. It's not entirely clear as to why the complainant had issues with getting her contract canceled, but there was no evidence the respondent was acting fraudulently to prevent the contract cancellation. The recommendation is to close.
A motion to concur with counsel. Second.
Second. All in favor?
Aye.
Aye. Opposed? Motion carries.
All right, thank you. Next, we have number 4, which is case number 2021018831. The summary is on or about March 10th, 2021. The complainant received a call from an individual stating he was associated with the respondent company and offering the complainant a free alarm system if the complainant agreed to follow the respondent to have a yard sign in his yard. The complainant asked for this individual's name and registration number, and the individual did not provide either of these. The respondent, which is a company that operates in other states, has a website that links it to another company licensed in Tennessee. The respondent's website does not explicitly state it does business in Tennessee and only states it works in partnerships with a licensed company. The board's investigator was unable to get in contact with the respondent company or the larger licensed company. The investigator was able to get in contact with a subsidiary of the larger licensed company, and this company indicated that it works with the respondent in Texas, where the respondent solicits business for them. This company denied the respondent does any solicitation in Tennessee and stated the respondent is lawfully registered to perform marketing relating to 8 different Texas area codes. The complainant does not have one of these Texas area codes, and this company stated it believed the individual who called the complainant may have called him with dishonest intentions and was not related to the respondent. Based on the investigation into this case, it appears that the person who called the complainant was unlawfully soliciting services that would have required a registration from the board, and although he stated he was affiliated with the respondent, there is insufficient evidence to prove this. Further, based on the statements from the company that partnered with the respondent, it appears that this may have been some type of scam, but there is insufficient evidence to attribute responsibility to the respondent. This is further bolstered by the fact that the respondent's address is located in Texas, and the phone numbers that were used to call the complainant did not appear on the information obtained for the respondent. Although a letter of warning or discipline is often warranted for a company using an employee who's not registered, there's insufficient evidence to attribute this individual's actions to the respondent. As there's not enough contact information for this individual who called the complainant, the board would be unable to discipline and serve this individual. Recommendation is to close.
Actually know who the individual is? I mean, you have it sounds like I thought in the end you were going to say you really didn't even know who the person making the phone call was.
We have a first name, and that was it.
Okay.
Mm-hmm.
But you feel like it may not have even been part of what the company that's the respondent?
Based on what we obtained, it didn't seem like there was enough evidence to make that connection. But there is a concern because it is if it's a scam, it's a very specific scam, and the fact that you would use another company's name for that, I'm not sure how likely that is, but based on what we obtained, we couldn't appropriately make that connection.
The possibility that when they were questioned or something of their license number or that they then gave out this other company's name, is that the thought? That maybe they were...
I'm not sure. The complainant actually is registered by the board, so I think that he is someone who appropriately asked questions of this individual on the phone. But unfortunately, we were unable to, we didn't get a last name, and the phone number that was used to call the complainant doesn't appear to be linked to any of the information we have for the respondent.
Don't require licensing for marketers as well. I mean, they need to be affiliated company that's
right, and that's depending on what was actually being said over the phone. But it would have appeared that he may have been trying to act in the capacity of some type of a sales rep as an employee. I don't know what type of information he would have required. I mean, it is possible that he could have obtained very limited information and transferred to someone who would have been required to be registered. So that's correct.
second.
Motion to close in a second. All in favor?
Aye.
Opposed? Motion carries.
All right, thank you. The next one is number 5, which is case number 20210267111. The summary is the complainant signed a 42-month service agreement with the respondent for monitoring services in June 2017. The contract required a 60-day notice to be sent prior to the expiration date to discontinue auto renewal of the contract. The complainant stated he sent this notice of cancellation on September 29, 2020, so that the contract would end at the term's expiration date of December 24, 2020. The complainant stated he was billed for services in January and February 2021, so he made this complaint after he had issues with getting his contract canceled. The respondent responded to this complaint and stated it reviewed the complainant's contract. The respondent canceled the complainant's contract as of the expiration date and sent a refund to the complainant for the amounts billed in January and February. As the issue has been remedied, the recommendation is to close this case.
Motion to concur with counsel.
Second. Motion and a second to close the case. All in favor?
Aye.
Carries.
All right, thank you. The last case is actually a case has been represented. I'll read the new information, but if you need me to discuss anything from the original summary, I can. This is complaint number 2020012091. Originally, the board had elected to issue a consent order to settle for a $1,000 civil penalty for unlicensed activity. The new information for this case, though, is that in discussing this matter with the respondent's attorney, he made us aware of the pending theft allegations against the complainant. Although we were unable to confirm these allegations, we did make contact with the complainant, who requested we drop the case as he did not want to cooperate further with us. Without the complainant's cooperation, we do not have any evidence of any alarm system installations. The respondent's website still advertises that it offers, quote, security systems, end quote, and, quote, security cameras, end quote. The respondent's attorney indicated these services are performed by licensed entities, although we never received documentation of this even after it was requested. The respondent's main business appears to be through services as an electrician, and that, as discussed previously, this individual who is licensed as an electrician was the complainant, who is no longer working for the respondent, and we have not received any information about a new licensed electrician working for the respondent. The respondent does not hold licensure as an electrician, but it may be employing individuals who hold individual licenses. This would be a violation for the Board for Licensing Contractors to consider, and as the complainant no longer wishes to cooperate with us to provide information about the respondent's work as it relates to alarm systems, it is appropriate to close this matter with a letter of warning to make a referral to the Contractors Board. So that's the new recommendation for this case would be to do a letter of warning instruction and refer this matter to the Contractors Board.
I understand the complainant may not wish to go any further, but if their website still says they offer security systems and cameras, still move forward. I mean, that's, even if they have licensed entities install it, they're marketing, selling.
Right. But I think part of the concern is, you know, when they had the licensed electrician working for them, which was the complainant, part of that, based on his licensure that he held, they could have easily taken steps to fit under the exemption for electrical contractors. Because if you look at their website, predominantly it focuses on sound systems, lighting, all electrical type work. They do have one tab, though, that then says security systems and talks about security cameras specifically. So that is something that we could go after them for, would be you know, holding themselves out as doing the work of an alarm system contractor without licensure. I think the concern is they could have pretty easily fit under that exemption. They don't have a licensed electrician on staff. And there are other violations that the alarm or the Contractors Board should consider for the electrical work that they're doing without licensure. But we kind of have two issues, and I guess one is we don't really, without the complainant, know what actual installation has occurred. We think it's more of just holding themselves out. And two, the fact if they are subcontracting that all out, it could be a violation at that point for holding themselves out, even if there's no actual installation. So it does appear more of an issue, or let me rephrase. The larger issue for them is going to be the electrician or the electrical work they're doing without a license. And I've made their attorney very aware of that. And, you know, you're looking at two boards potentially disciplining you. And, you know, if you get it right with the Contractors Board, you can fit under the exemption here. And he didn't really take that to heart, it seemed like. So I think if we wanted to continue to proceed with charges, it would only be for that holding themselves out aspect of it, because we no longer have evidence. And even if we subpoenaed the complainant, you know, we could try to get it that way. But there is issues with his credibility if he's facing at least a civil case at this point for embezzlement.
They would need to register as even if they were trying to get the exemption, and they never.
Right, they haven't done that.
And they couldn't without the electrician, or.
Correct.
Under their tab, is it just talking about cameras, or do you know?
It's what it seems like. I didn't see, you know, burglar systems. It seems just to be cameras. But I think that's part of the issue, too, is the complainant kept saying it was alarm systems, and now that as soon as we went to investigate it, he first told us, put this case on the back burner. And then when I followed up with him as a witness potentially afterwards, because I did want to get information as to how many alarm systems, what are we actually looking at, he wouldn't provide any of that, neither would his attorney.
I'm sure it was motivated by his parting ways with him, but that doesn't mean that the activity wasn't probably still happening. Like, I mean, would he have said anything if he hadn't had any issues? Probably not, it sounds like, but I think there was still unlicensed activity going on.
One other thing that I think we could do, because I think part of the motivation with this recommendation is to at least get the contractors board to do their part of it with that issue. If you did want to continue to pursue charges, we could reject that recommendation in terms of the letter of warning, continue with the authorization to pursue formal charges for unlicensed activity, but still make a referral to the contractors board, if that's something that you were inclined to do.
I would be willing to, as long as we're referring it to the contractors issue, but I wouldn't want it to be dropped there. But you feel like there's enough there on this.
I do.
Even more.
I do. I think that there's, first of all, they've got, the website is predominantly an electrician service website. That seems to be their majority of the work that they do. But even if they were licensed over there, they still have a violation for potentially doing business under a name other than the one in their license. So they really have two potential issues. One, unlicensed activity. Two, if they have gotten a licensed electrician back on staff. Because I did verify again recently, they're still not registered under their name for electrical contracting. And based on the types of projects they're trying to do with these lighting systems and sound systems, that seems to be a lot of their business and where they're making a lot more money. So I think that there's a potential very large unlicensed activity case for the electrical side of it. I'm not sure in terms of alarm systems how much they're actually doing. We could still discipline them for holding themselves out as an alarm system contractor without a license, but it is a little bit iffy in terms of if it's security cameras or if they're actually doing a more intensive burglar system.
I'll make a motion to concur with council to refer it to the contractors board, and to your recommendation is to close the complaint, or to
do it with a letter of warning. I think would be the best way. If the only evidence we really have is that website, at the very least, then if we find out that they are actually installing systems later, if something came out with litigation in the contractor case, potentially we can try to look at that as a separate issue.
The motion is for council.
I'll second.
Have a motion and a second. All in favor?
Aye.
Aye.
Opposed? Motion carries.
All right, thank you. And that's the last case from the legal report.
So next we have appearances.
We don't have any.
I'm going this way. You're going.
Well, I'm looking at the agenda.
You're going by the agenda. I'm just going by what comes next.
We can move on to administrative matters if you.
Yes, please.
Okay. Like the first thing we have under that, under administrative matters, is the budget for alarm systems contractors. And it looks like for the month of May, if you have it in front of you, we did operate with a surplus.
Oh, you got?
Yes, sir.
Okay.
Got a lot going on there.
All right.
All right,
Move along to legislative update.
yeah, I don't have anything there. Maybe, Jesse, do you have anything
I think just
you want to mention?
briefly, since it does affect, I know we've talked about it a little bit previously. As we previously discussed, House Bill 781 and Senate Bill 770, it's also called the merger bill, was introduced previously and potentially had several effects on the Alarm System Contractors Board, as well as just the Alarm System Licensing Act. That was actually signed into law April 30th. Most of the provisions will go into effect July 1st then. It can be found at Public Chapter number 294 until all the provisions are actually changed within the law individually if you look it up. But just a couple different things that I think are important to bring to the board's attention. I've brought them to the other commissions, the Private Investigation Commission, things that affected the industry, so I think I'll do that for alarms as well. I think the first thing under the law that's important to note, the definition of an alarm system actually changed under this law, if you weren't familiar with that. It's made it a little bit more streamlined. The new definition for what an alarm system is will be any electrical device, signaling device, or combination of those devices used to signal or detect a burglary, robbery, or medical emergency. So it's a much shorter definition. It's still a little bit broad, so I think there are still going to be questions in terms of what technology will be under this or not under this. But I do think they tried to make that maybe a little more streamlined. The next section that I think that is something to, I guess, consider, the education for a qualifying agent has also changed under this new law. Now it will be an applicant must hold a post-high school degree from an accredited university, college, or technical college approved by the commissioner, or the applicant must hold a current certification by a national training program approved by the commissioner in the field of work to be the field of work to be installed, serviced, or monitored, and have at least 3 years working experience in the alarm industry covering the actual installation of those alarm systems. So that's a much lower bar to meet for qualifying agents. And then another, just kind of two things from this I think are important to look at. This bill, as we have discussed previously, will have the alarm system contractors all run under the Department of Commerce and Insurance and regulated by the Assistant Commissioner and the Commissioner instead of the board. It does create an advisory committee at this time. My understanding is we haven't started that process. They're still kind of seeing how that will go, so there hasn't been any type of selection of a committee or committee members at this time. So that's kind of where we are with that. The only other thing I think that is worth noting, there is a section that removes some language about CCTV. Under the actual bill, though, in its effect, it doesn't remove that as a classification.
That's what I wondered about.
Right. So we've had some internal discussions about that because there were some individuals who believed that CCTV was no longer going to require classification. My reading of the laws, this one as well as the laws that were in place, it's still intact as a classification, and it's still actually intact in a few different areas. So realistically,
Change the definition, if that doesn't.
I think there was a little bit of confusion. I know that a version of this that was discussed previously was a little bit different than the one that I think was passed. So I'm not sure if there will be another bill later that removes that. But at this time, though, CCTV is still a classification.
That was even in the financial judgment. Revenue would go.
Right. I'm not sure. There was a little bit of confusion, so I'm not sure if we'll see another bill, coming later that removes that. But at this time, though, it's still in place. So I just want to make sure everyone was aware of that. Yes.
Interim between the advisory board being set up and now, who's going to handle this?
My understanding is it will be the assistant commissioner. So that's a good question. We've had some discussions about that and how that will work. I think there are some processes being done potentially to have some experts similar to what we're doing, with the board. We treat you all as experts. to be able to ask questions. I'm not sure what that will look like. So I think that we'll wait and see. But I think that in terms of technology, that's definitely going to be a question that will be asked.
So my understanding, because I've had lots of emails about all this, is the advisory committee is actually up to the commissioner if he chooses. He doesn't have to do it.
Correct.
So therefore, it's up to Cody, you, and somebody else to regulate the place.
Well, I don't know if I would say it's up to me and Cody. You know, my job is just to make a recommendation based on the law. So,
well, welcome to your new job.
Right. I would like to think that I'm not being given that type of power because there are a lot of things that I still ask questions about. But no, it will mostly come down to the commissioner and the assistant commissioner. But we did have a discussion. I know Director Vest and I have had numerous discussions about this in terms of what, even saying, you know, what a committee could do or could not do and what that would look like. So at this time, it hasn't been formed, no.
Sounds like just by the name, the advisory committee may advise to do something, but it ultimately comes down to the insurance commissioner's decision. I mean, it may be 1% of the time as with the advisory board.
Yeah.
Ultimately, it's his decision, or his or her, as the case might be.
So basically, the politicians have taken and shut us down, and they don't have a clue what they're going to do yet. That's where everything I'm reading and being given information from others who have met with Cody and the commissioners, that they really don't know what they're going to do at this point. You know, people are asking me, you know, who's handling complaints? Well, that's up to Cody now, apparently.
Well, it'll be the assistant commissioner who will be handling complaints.
So the assistant commissioner is going to handle all this stuff that you just read.
That's correct. So the assistant commissioner actually already handles our private security complaints. So now we'll basically run them, and that's something we're still trying to figure out too, if we're going to run one legal report with private security, private investigators, and alarm system contractors. So I think that it will be a little bit of a learning curve, but I think there will be a lot of discussion, I think, as we move forward to figure out the best procedure.
You're not a politician.
All right, anything else with that we need to go over?
Unless you all have any other questions. That's correct. Mm-hmm. Right. I haven't heard that being discussed at all. Just to throw that out there, I haven't heard any discussion on that.
My registration expired about the 30th of this month. So, I mean, I've already renewed, but it's like, is it all going to change the next day?
No, based on, I would be surprised if there was a change with fees or anything like that. I know some of the other, the Private Investigation Commission had a lot more changes in terms of individuals who would actually need licensure or not need licensure. So we had a lot more questions about that. You know, with CCTV not being removed at this time, you know, I would tell people to contact an attorney if they have questions about, you know, what type of, not me, you know, I can't give them legal advice. I'm an attorney, but not their attorney. But I would tell them to contact a private attorney with any questions about renewing licensure, what type of classifications they would need, just since we can't give them that advice. There's not any major changes, though, in terms of classifications under this bill.
At this time.
At this time.
At
right.
this time.
That's correct.
Which is request for extension. We don't have anyone requesting for an extension at this time. And move on down to the criminal history review.
So with all that was just said, this is your all's problem to figure out now. It's not ours, really. Who are you going to go to when you have something like this? Nobody knows. So you hire a new person that has a criminal this thick, you're not coming to us.
Right, so I think that these will all go through the assistant commissioner, and he'll make those, or the commissioner, whoever he designates for that, will go through these criminal backgrounds and make that decision. So I know the assistant commissioner for regulatory boards does review these for private security already, so he'll likely, unless they change it to someone else, be reviewing these as well.
Someone's already reviewing, given certain question through these, them coming.
That's correct. Right. That's normally on Cody Vest's team for the approvals, for some of those ones that don't have the questions. It's usually like these three that we have today. Those are the ones where there's, questions that someone needs to make that determination. So going forward, based on this bill or this law, it will be someone designated by the commissioner.
At this point, the commissioner will be the one that looks at this and says, yeah or no.
Correct.
Maybe.
I have a few notes. Person works for a monitoring station. They did answer yes to the arrest questions. The records check review shows a conviction of hit and run in 2012. Probation, 2015.
You're referring to Teresa Gaza? Make sure we're on the same. Okay.
Applying for a
don't have any left.
There at her notes. All there is, okay. That is her explanation.
The application is for a registered employee for monitoring.
Yes.
Make a motion.
I'll second.
Motion and a second to approve. Everyone in favor?
Aye.
Opposed? Motion carries. On to.
Person is also registered employee. Say yes to the arrest. Was an arrest theft in 5/6 of 19 is found guilty of theft. On
I'd say we'd like to see doctors, but I don't get.
Got a few hours, right?
My first reading is he said some of this happened when he was 18, and then I read on through and see the dates of some of it, and it's fairly recent, so 18 was not that long ago for him.
Don't know what he's gonna be. They tech, did I?
Well, he's applying, obviously,
Oh,
they're planning to work him in Tennessee because he's applying for Tennessee, but he's a tech, yes, and
okay, I missed that one.
it says he lives in Mississippi, but he may work full-time in Tennessee. Can somebody left?
Not on the call, is he? Is he on WebEx?
Dustin is.
Oh, no, not Dustin, I'm sorry, Mr. Kilpatrick.
Yeah.
Okay. I was just thinking that may have solved that issue.
Right.
I was gonna say, yeah, if he was listening in, that'd be
Right.
perfect. But that's more your end of the state.
Well, it doesn't really matter. I don't-
I'm just kidding.
Um, Open to hearing any other thoughts, but mine,
Well, the sad part is if we deny it, they're gonna continue to work him if he's any good. You know, it's a fact.
Stop us from doing
Yeah. Going into homes and being convicted of theft doesn't typically go together.
that. Would be a little.
If you are looking at denying it, we will go through the Fresh Start Act. I think some of the factors that, both you all, Doug Praker and Scott Cockcroft have brought up are the length of time since this actually occurred. It looks like it was about 3 years ago is when it occurred. So that is one of the factors on there. If you'd like me to read those factors now into the record for consideration, I think that could help. So if you all are considering denying this license, there are some factors under the Fresh Start Act that we would look at first, such as the nature and seriousness of the crime for which the individual was convicted, the length of time since the commission of the crime. I know that factor was discussed a little bit already, with it being about 3 years. The relationship between the nature of the crime and the purpose of regulating the occupation, profession, business, or trade for which the license, certificate, or registration is sought. I believe that's also what you had brought up with theft and going into someone's home. The relationship between the crime and the ability, capacity, and fitness required to perform the duties and discharge the responsibilities of the occupation, profession, business, or trade. That also would likely fall under that factor as well. Any evidence of rehabilitation or treatment undertaken by the individual that might mitigate against the relationship of the crime to the occupation, profession, business, or trade, and any applicable federal laws regarding an individual's participation in the occupation, profession, business, or trade. So those would be the factors that you would consider before denying this application.
Problem following most of those under this situation if we saw fit, but it's a matter of what the board deems as
make a motion to deny based on theft, going into homes, and the length of time it's been. You know, he's 22 years old. Like I said, this is he was 18 when this happened. That's only 3 years, 4 years, depending upon when it was. That's it.
Have a motion and a second. All in favor?
Aye.
Opposed? Motion carries.
Person is registered employee, sales representative. There's still a case.
Mark, I can't hardly hear you, but.
Hard to hear me, I'm sorry. Still an open case as well. He has open charges. Open charges.
Type of probation from that open. Particular case. I have a motion. Question is that. I think for me, would be, yes, certainly I'm concerned about his past convictions, but the fact that he's in the middle of a conviction that we don't know the outcome of, I think personally for me, that would be reason enough for denial. If other cases are on probation and so forth, we don't approve them until that's over. We don't know what the outcome would be here. I think that in itself would be.
I think the other side of that, though, is he's innocent until proven guilty. It's different if he's on probation, but I don't know that we can.
We could just hold this complaint open until application open.
I think that probably the most troubling for me. That is prescription for the first, whether it was auto insurance related. It's the 2018 conviction. Most concerning for me that that's what his application is. Sales rep. That's what he was doing. 17 for We had a motion.
Motion to deny or to leave? Motions to,
What happens at this point? It would open. I mean, it may be sooner. He right back again.
Motion to deny. What
Second or that.
that was second. That was second to deny.
I think we leave it as an open, as Jesse was saying, for Cody, whoever, to reach out to him to get more information and try to get this most current charges resolved. It's a good legal term. Politician. Motion to defer.
Motion to defer. We have a motion.
Second.
We have a motion and a second. All in favor?
Aye.
Opposed? One opposed. Okay. Motion carries.
That concludes our, part of the criminal history review. Y'all want to take a break or anything? Hold on, or?
Roll.
Rock and roll.
Okay.
Did you send these out to certain people, or?
Okay. Oh, that was emailed to all the board members.
This one did not get anything. I didn't get anything.
I got it.
I got access.
I got access.
I got it. The three of us, I think, got all of it.
Okay.
There should have been an attachment in the email that had all the documents. That, PowerPoint was hard to attach, so that's why I
looked at all of the documents that were attached, but I didn't have PowerPoint on what I was looking on them. So I looked at that. Everything looked fine to me. I think some of them are I mean, the list that says continuing education, the way the list is presented, that's fine. Some of them are checked off for everything, which they wouldn't be. But if we go by the education review report, they're all marked for continuing education, and I would recommend all of them as the report.
Say all of them, you mean everything on this list?
Everything on this list.
Okay.
I've looked at all of those, but several of them on their actual form, it's typical, they check everything, but they wouldn't be applicable for employee training or initial application, but they would for continuing. All of them are for continuing ed and wouldn't be applicable for anything else. Checked everything? Okay. Ask for the most and take what you can get or whatever.
Read all these wants to read all these into the record, and we don't have a motion on this yet, but all of these courses, do we have an agreement that they're all good for continuing ed, or?
I'll make it official. I'll make a motion that we approve these for continuing ed. How does that work?
Second.
We have a motion and a second to approve the following courses for continuing ed. ADI Academy for 1 hour, AMG Uniview Tech for 2 hours, Access Communication for 2 hours, Nortec Control 1 hour, Nortec Control 3 hours, Nortec Control 4 hours. We have a motion and a second to approve all of these for continuing ed. All in favor?
Aye.
Opposed? Motion carries.
Have any unfinished?
Not that I can
Business
think.
that we have to present?
On election of last meeting. I guess it doesn't apply today.
Lou, you have been elected as chairman, vice chair, secretary, everything.
Well, we will mark the Launch System Contractors Board adjourned for the last time. Thank everyone for their service.
Work with many. Started here, same chair.
If they're officially adjourned, I can say something.